call this meeting to order. Welcome to meeting number 60 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of March 27, 2023, the committee is meeting begins its study of Bill C-41, an act to amend the criminal code and to make consequential amendments to other acts. Today's meeting is taking place in hybrid format pursuant to House Order of June 23, 2022. Members are attending in person and in the room and remotely using the Zoom application. I'd like to take a few comments for the benefits of the witnesses for the members. I think there's nobody on Zoom. Nope, so we're okay. We'll skip that, and I think all of you are familiar with our mic issues and how to get your translation services. On our agenda today, we'll be proceeding to the clause-by-clause study of Bill C-41, and if it permits, we'll try to begin the in-camera our study of the draft report on extradition. If it's not possible, we will continue doing that on Wednesday. Before I begin the business of today, I want to give Ms. Dillon a wishful happy birthday. It's her birthday today, so happy birthday, Ms. Dillon. Back on our first item of business today, we will have officials with us. We have Mr. Gilmore, Mr. Brookfield, Mr. Bilodeau, Ms. Lowton, and Ms. Beatty here to provide answers on technical questions throughout our study today. So welcome to all of you for being with us today. I'd like to provide members of the committee with some reminders on the clause-by-clause process. Members should note that any new amendments must be submitted in writing to the clerk of the committee. During debate on the amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. So if that concludes it, we will continue with clause by clause, and the chair calls clause 1. And I believe we have NDP 1. We just call, yep. Ms. McPherson.
Thank you, Mr. Chair. So we've brought forward a recommendation, clause 1. We've sent it to everyone, of course, and it is going to be replacing on line 8 on page 1 with the following: 10 years who directly or indirectly, adding willfully and without lawful justification or excuse, collects property or, end quote. And section B by replacing line 18 on page 1 with the following: years who, directly or indirectly, willfully or without lawful justification or excuse, collects property or PRO. As per that. Now, the reason we've done this is we've asked the sector, and they have recommended that we insert this word that reflects the lawful justification of performing humanitarian activities as per international humanitarian law in territories that's been controlled by a terrorist group, and which would allow for coherence and uniformity with the other provisions of the terrorism section of the criminal code. So basically what we're doing is inserting that language.
As amendment to NDP 1, shall it carry? Is that how it go? Okay. Just making sure my language is good. Shall the amendment to NDP 1 carry? Yes. Yes. And NDP 1 as amended carry? Yes? Okay, good. NDP 2. I believe a new version has been circulated earlier today with the reference number 12356266. This is the version that the committee will now consider. If NDP2 is adopted, several instances of the words terrorist group, in quotation, in the bill would be changed to listed entity. Members may want to remember this when considering subsequent amendments that use either term to ensure consistency throughout Bill C-41. Shall NDP... Sorry, Ms. Nellis?
Thanks, Chair. So this is directed to officials, I think. Can you give us the difference between a listed entity and a terrorist group, and why why it is defined as terrorist group and not just listed entity, please?
Thank you for that question, and maybe I'll start and give an opportunity to my colleagues to weigh in. That terrorist group is defined in the criminal code. A listed terrorist entity is a terrorist group that has been listed as per the criminal code and has gone through the listing process through the government. And so a way to put it is a listed entity is a terrorist group, but a terrorist group isn't necessarily a listed entity. One of the things to consider here is that the use of the listing group in the amendment is intentional to capture a broader or the correct offense that exists currently in the criminal code, where it is a criminal offense to knowingly provide benefit to a terrorist group, and therefore, changing it to listed entities. One of the considerations to think about is how that would potentially restrict significantly the scope of the offense, and just focus on listed entities as opposed to the listed groups, which is currently, or the terrorist group, which is currently what is in the criminal code. I don't know, Robert, if you want to weigh in on that.
Just to elaborate briefly, so the two definitions of terrorist group are listed entity or an entity that has as one of its purposes or activities facilitating or carrying out any terrorist activity. So if, for example, there was some group, a hateful group, that white power group that does a terrorist act, but is fundraising for various purposes, including perhaps its publications, the day after the terrorist act, it probably would not have been listed yet because there would not have been time to do so. But right now, as the law stands, that it would be against the criminal code potentially to give money to that organization because it is a terrorist group, albeit unlisted. So the effect of this amendment would be to remove that potential liability.
It would severely restrict what would fall under the umbrella of this bill then. It would only be those that are listed entities and not the second group that you described. Is there a reason we didn't use that particular wording in the bill? A terrorist entity or the second part that you used that's in the criminal code?
Well, to clarify, the first part of the amendment doesn't just amend the ability to issue an authorization, it also amends the crime itself. So the crime itself would essentially be more limited, such that whether in Canada or abroad, an individual who gives money to an organization that carries out terrorist activities would not be prohibited, as long as it's only giving it to the organization, not knowingly for a terrorist purpose. That's in 83031 as the present bill C41 would provide, and that stays in.
I may have another question, but I'll leave it for now.
Just call me.
Ms. Thomas. McPherson,
I
sorry.
was going to say,
What am I doing? Long day.
Mr. Chair, we know each other. You know who I am. So my concern with this, of course, is that basically what I'm hearing, and correct me if I'm wrong here, is that we are expecting that the government can't move fast enough to add necessarily organizations to a listed entity, but we are expecting CSOs or organizations to be able to respond to that without being able. We're expecting them to be faster and more mobile, I guess, is what I'm sort of hearing. So how on earth would an organization know that they were breaking the law if there is no way for, one of the things I'm really concerned about with this whole legislation is we're making some assumptions about who's involved in international development, who's involved in projects abroad. They are not all organizations that are very large, that are following along with every single thing that the government does. They are not organizations that necessarily even interact with the federal government, but would still be held accountable to this law. How on earth would they know who? How would they know when they're at risk, their organization is at risk of breaking the law?
If I maybe can just take that in two parts, is the amendment that's being discussed right now would very much restrict the scope of the offense. So that's the first thing. It's leaving aside the authorization regime, the amendment to the offense would take the offense from financing terrorist activities to a terrorist group and limit that offense to listed terrorist entities. So even if we could do it within a matter of weeks, there would still be a period of time where there would be currently an offense, but no longer if the amendment was made to the provisions. NGOs that are operating in this space, a lot of them know the areas in which they operate and they have information about that. No, absolutely. I concur that there are larger ones that are more familiar with some areas, but that to that extent that there are resources out there available, and we are as a government able to provide information if asked, and people engage with us as well.
What resources are available out there for this particular thing if this legislation hasn't been passed yet?
So I will turn over to my colleague because she is the counterterrorism expert.
So you're quite correct. The legislation has not yet been passed, but we certainly hope to be able to provide some guidance in its applicability. We need to see how this is going to play out. And I'd also like to point out that one of the challenges in restricting this applicability to just organizations that are listed is it means that there's no protection from liability if you are engaging with an organization that for a variety of reasons can't be listed under the Canadian Criminal Code. And there are some organizations out there. I take your point that this could be difficult for smaller organizations, but I expect that they would be in contact with us by virtue of their application process. And we, I hope, would be able to provide them. Well, they'll have to apply, right? I mean, we've talked about this before. There's going to be the Government of Canada website, and we would have to apply, and you would notify. Well, there's going to be a single window application process. I think we spoke about this last time.
But they won't know to apply because they won't know which organization, which areas are being run by a terrorist. So they won't know, like, let's say, I'm picking a name totally at random. Let's say Nicaragua. One day to the next, it changes within the mind of the government of Canada. Anyone working in Nicaragua isn't going to know that. And so they're not going, how are they possibly to understand that they are now breaking the law? So the onus has now been put on small and medium organizations when the onus rightly belongs on the government to provide that information.
Right, and I think what we're doing here in constructing this broadly and flexibly as we can, is so that we can respond to those sorts of evolving situations. So organizations bear a certain amount of responsibility for where they operate, and I think we can all agree that that's sensible. We're encouraging organizations to operate internationally, where they can handle themselves, where they need support, we help to provide it. They will have to be able to respond to changing circumstances. I think we all do that. And if the situation changes, and Nicaragua is a great example. We're not talking, well, Nicaragua is a great example because it's a volatile place at the moment. I think they would need to be able to look at what they're doing and where they're engaging and seek guidance where we can provide it.
So Monday they're allowed to work, Tuesday or Thursday they're not allowed to work, but there's some way for the government, there's no way that the government has an obligation there. It's the obligation of the organization to continually keep track of what the government is thinking, not through a way that will be publicly expressed in any way, but just sort of by sensing it.
So the government is not the ones requiring them to seek a license. We're providing this as an opportunity to allow them to continue operating in an area where they may encounter liability. They would need to make that decision, and they would need to seek independent legal advice. We can't provide legal advice, and we are not requiring organizations to seek this license. It would be something that they would be able to pursue should they deem it necessary.
Mr. Genius?
Point d'ordre, Monsieur le Président. Monsieur le Président.
Point of order. I have a point of order. I'd like to ask my colleagues to be careful because with the interpretation, there are two questions that I didn't hear. I only heard the answers. I understand that everyone is very involved, but let's be careful so that we allow our interpreters to do their work and to the francophones who are listening to be able to hear all the deliberations. Thank you.
Thank you, Mr. Bernal-Lesseps. And now, Mr. Genius.
Thank you, Chair. I'm listening to the discussion, and I'm sympathetic to both sides of it. Insofar as I think we do need to look at amendments that create an obligation for government to provide information to humanitarian organizations, either by publishing that information publicly or at least making that information available to those organizations in some way, so that they're not guessing about what areas or what organizations that they can have some good, reasonable guidance around that. My view of NDP 2 is that it makes changes to our terrorist financing framework that go substantially beyond just the issue of humanitarian organizations. My reading of it is that it in fact changes our terrorist financing frameworks such that that you can only be charged with terrorist financing offenses if you are financing a listed entity, which is a change from the current law, where you could be charged for financing a terrorist group that's not a terrorist entity. And I see some of the officials nodding, which suggests maybe I'm on the right track here. So we're not just talking about humanitarian organizations. We're talking about if a new organization that the government of Canada is not aware of emerges on the scene, is involved in explicitly terrorist activity, and somebody in Canada is intentionally organizing fundraisers for that organization, they cannot be convicted of terrorist financing offenses if that organization is not yet listed. And so my concern is just that we should try to limit the impacts of our amendments to terrorist financing law today to apply to the things that are necessary to enable humanitarian organizations to do their work, and not do things in the context of this bill that are going to make broader, more dramatic reforms to terrorist financing law. There may be an argument for saying, look, the government should list every terrorist organization. They shouldn't be financing. They shouldn't be convicting people for terrorist financing if they're funding groups that are not listed, and the government should do the work of listing. I don't personally agree with that argument. I think maybe there's an argument to be made, and that's an issue that could be studied. But I would just say let's limit our deliberation. My suggestion would be let's have this bill deal as precisely as possible with the circumstances of humanitarian organizations. So on that basis, I agree with some aspects of the intention. I don't support NDP 2, but I think we do need to look at later amendments that would create obligations on government to provide information to development organizations that would help them do their work.
Thank you, Mr. Genuis. Now, Monsieur Brunel Duceppe.
J'ai déjà fait.
I already made my point. It was for the interpreters. Thanks.
Thank you. Sure, Ms. McPherson.
So I guess from my perspective, I'm just wondering what amendments the government or the Conservative Party would be willing to bring forward to deal with this, because this is a concern.
Mr. Genuis.
We have CPC 2, which is later on in the package, and I think we've been discussing informally some possible changes that address concerns the government may have with CPC 2. I think it's good for us to try to work towards a consensus. CPC 2, in its current form, requires the Minister of Public Safety to publish information on the website of the government that would indicate the organizations that the government views as terrorist groups for the purposes of these provisions around humanitarian assistance, as well as the areas where they believe this is happening. And it says that no person shall be convicted of an offense under the subsection if they establish that in good faith they provided or supported the provision of international development assistance on the basis of information published under the previous subsection. So I think, certainly we're open to some wordsmithing around that amendment, but this amendment tries to create that obligation on the government to provide information without making the root and branch changes to terrorist financing law that I think would result from the adoption of NDP 2.
Ms. McPherson, do you want to move your NDP 2? I think it's already moved. That's already okay. Okay, so shall we vote? Shall NDP 2 carry? Do you want a recorded vote, or how do we want to do this?
Okay, on the new NDP 2, Madam McPherson,
Yes.
Mr. Genuis,
No.
Mr. Moore,
No.
Mr. Brock,
No.
Mr. Van Popta,
No.
Madame Damoff, no. Madame Brière,
Nope.
Madame Diab,
No.
Monsieur Nagby,
No.
Madame Dillon. Oh, oui. Oh, désolé. Merci, désolé. Monsieur Brunel Duceppe, pardon.
Oui.
Je m'excuse, désolé.
Yea 2, nay 9. It does not carry. Now we have. Sorry? Okay. Ms. McPherson, would you like to move NDP 3?
Yeah, yes, I believe they're all moved. Mr. Chair, NDP 3 is, I think something that we all have heard from the testimony is very, very needed to make this bill useful. This is the humanitarian carve-out that we had hoped that the entire bill had been. I think that all of the opposition parties have been asking for this for a very long time, for over 18 months now, to have this legislation in place. When the legislation was tabled, when C-41 was brought forward, that carve-out was not in this legislation. So this is an attempt. I think we've heard enough testimony from enough different groups that I think I have all parties want to find a solution to ensure that there is a humanitarian carve-out for organizations. So we would be asking the committee to consider the following. Subsections 1 and 2 do not apply to a person who carries out any of the acts referred to in those subsections for the sole purpose of carrying out humanitarian assistance activities conducted under the auspices of impartial humanitarian organizations in accordance with international humanitarian law, and by deleting lines 15 to 19 on page 2.
Thank you. Mr. Genius?
Yeah, Chair, we are directionally very supportive of this. I would like to propose a sub-amendment that I think will find support. It kind of... Oh.
Mr. Genius, I actually have to make a ruling first.
Oh, okay.
So I thought you were making comments. The ruling is Bill C-41 amends the criminal code to create a regime under which the Minister of Public Safety and Emergency Preparedness may authorize an eligible person to carry out in a geographical area that is controlled by a terrorist group and for certain purposes, certain activities that would otherwise be prohibited. The amendment proposes to allow a person to carry out such activities in a geographic area that is controlled by a terrorist group without authorization from the minister. As House of Commons Procedure and Practice, 3rd edition states on page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of this bill. In the opinion of the chair, the amendment proposes an exception to both the subsections 83.03 subsection 1 and subsection 2 that would not require the minister's authorization, which is contrary to the principle of the bill. Therefore, the amendment is inadmissible. So it's a non-debatable issue unless you want to challenge the chair. Mr. Brunel Desep?
Oui, ben, mon chef.
I will contest the decision of the chair, or challenge, rather, the decision of the chair.
Find the chair's ruling defeated, agreement to defeat the chair's ruling on division.
Okay, so shall the chair's ruling be sustained? You don't take the... No. Okay, so it has been defeated?
So do we seek to defeat the chair?
Yeah, that's right. And they're seeking to defeat the chair's ruling. You want to...
Is there agreement to proceed in this fashion?
Ms. Damoff?
We would vote to support your decision if there was a recorded vote.
He's not asking for a recorded vote.
I mean, if one member requests that we can do a recorded vote, I'm just trying to move through this.
That's fine.
Okay. Okay, so the chair's ruling defeated on division.
So the chair's ruling is defeated on division. Now, do you guys have... So now I go shall NDP 2.
No. The amendment is now open for debate, so we can let the members debate it.
Okay. Now now it's debatable. So, Mr. Jenius, you're more than welcome to speak.
Thank you, Chair. So I'm now moving the sub-amendment, which is simply to add to the end of the text in the new 4 to add at the end, while using reasonable efforts to minimize any benefit to terrorist groups. So I think that that provides clarity that in the process of providing this assistance, the organizations involved should make reasonable efforts to do all they can to absolutely minimize flows or benefits to terrorist groups. I think that's fairly obvious. It may already be implied by the existing language, but I think it is a good point to underline very clearly. Certainly, the organizations that we deal with seek to do this anyways, and I don't think have any objection to just the added clarity in the law around that expectation. Thanks.
Mr. Jennings will have to have your amendment in writing.
You do.
You do. Mr. Clerk?
Yes. On the side.
Sure. Do you have it in writing?
Have you sent it to me? Yeah, I sent it. Okay.
Do you want to read the amendment while he just searches it, Ms. Damoff?
Yeah, so just adding the words while using reasonable efforts to minimize any benefit to terrorist groups. So the whole thing would read, subsections 1 and 2 do not apply to a person who carries out any of the acts referred to in those subsections for the sole purpose of carrying out humanitarian assistance activities conducted under the auspices of impartial humanitarian organization in accordance with international law, while using reasonable efforts to minimize any benefit to terrorist groups.
Ms. Damoff? Oh. Ms. McPherson, my apologies.
I can be everybody at the table.
I've called her Ms. Thomas today.
I'll just do this on my own.
Damoff, Ms. McPherson, Ms. Taylor, I think I've called you everything today. So, Ms. McPherson.
Thank you, Mr. Chair. I just wanted to say that I am supportive of the sub-amendment to our amendment, and I did want to just point out that I do believe that we have heard from MSF, from the International Red Cross, from Leah West, from the Aid for Afghanistan Coalition, so that there is quite a lot of support within the sector for this. As I mentioned before, this is something I believe should have been part of the legislation at the beginning, and I would like a recorded vote on it, please.
Okay. And if everyone has the text, shall we vote on the sub-amendment? Or does anybody need time to read it? You're okay. Okay, so recorded vote on the amendment to NDP 2. Sub-amendment. And to sub-amendment to NDP 3, my apologies.
Okay, on the vote on the sub-amendment to NDP 3, Mr. Generous.
Yes.
Mr. Moore. Yes. Mr. Brock.
Yes.
Mr. Van Popta.
Yes.
Monsieur Brunel-Duceppe.
Oui.
Madame McPherson.
Yes.
Madame Damoff.
Yes.
Madame Brière.
Oui.
Madame Diab.
Oui.
Monsieur Nagvi.
Yes.
Madame Dillon. Okay. It's unanimous, Mr. Chair.
Unanimous and carried. So shall NDP 3 as amended carry?
I think we got it just so that we can show that there's all parties.
Right, okay. Recorded vote.
Okay. Okay. On NDP 3, as amended, Madame McPherson,
Yes.
Mr. Ginwis,
Yes.
Mr. Moore, Yes. Mr. Brock,
Yes.
Mr. Van Popta,
Yes.
Monsieur Brunel-Duceppe,
Oui.
Madame Damoff,
Yes.
Madame Brière,
Oui.
Madame Diab,
Oui.
Monsieur Nagvi,
Yes.
Madame Dillon. It's unanimous, Mr. Chair.
Unanimously carried. Thank you. Next, I believe, is it point 1? Is that what we do? Yeah. Block amendment 0.1. This amendment is not in the package. It was circulated in a separate document along with version 2 of the package by email before the meeting. Yeah. Monsieur Brunel Duceppe, do you want to move this forward?
Oui, ben, je pense que
Yes. I think that it's logical and it's what we were asking for. We heard this in the committee. This is what the organizations, the humanitarian organizations that need information, they were asking for this. I think it's very clear and simple. It's clear. And I even think that it's very similar to NDP 4. It's almost the same wording, if not, it's almost identical to NDP 4, except we add a little bit more. And I think that everyone should vote for this amendment. Thank you, Mr. Chair.
If you're referring to the right amendment, it's 1, 2, 3, 4, 1, 5, 9, 7.
No, sorry, I have the wrong one. It should be this one here.
Sorry.
I didn't. It
1,
should be
2,
this one here, sorry.
Yep, 1, 2, 3, 4, 9, 5, 3, 0. Is that the one you're referring to?
moi, je parle de l'amendement.
I'm speaking about block 1. This one. Oh, the one I sent just before the meeting. Oh, yes, sorry. We're not talking about the same one. No, I'm going to withdraw that one because we consulted. I thought we were talking about block 1. Sorry. Sorry.
Now we will speak about NDP 3.1. This amendment is not in the package. It was circulated in a separate document along with version 2 of the package by email before meeting. Just want to make sure everyone has that.
Does everybody have it?
Yeah, reference number is 1235608.
Yes.
Chair, just on a point of order,
Yes.
I didn't see any of these in a new package. Oh, thank you.
I'll just give a quick minute for everyone to read it who hasn't. Sure, go ahead, Ms. Dem.
Thank you.
McPherson.
So basically what this is something that's been asked for by the Aid for Afghanistan Coalition. What we've done here is we've added in substantially controlled Now, I do have to say that I have to, the way that this is all gone, I have to sub-amend this amendment because listed entities are, of course, that amendment didn't pass earlier. So the only thing we're really adding in there is the substantially controlled. And we would change those listed entities back to Terra Group.
Ms. McPherson, you can amend your own amendment, so somebody else will have to amend that. I'll go to Ms. Genuis and also see if he's the one who's going to be doing that.
Simply because it's impossible to write an amendment based on, we can
How,
do it.
how convenient. I do think a member is able to move an amendment that's different from the one they submitted. But anyways, for simplicity, I have submitted a draft sub-amendment to this amendment just now to the clerk, depending on how fast the internet's working today, that proposes to, in the first bit, replace listed entity with terrorist group. Actually, in all three places that it says listed entity, crossing those out and replacing them with terrorist group.
We're going to go through this a few more times.
The effect of that would be to align with the proposal of the Aid for Afghanistan Coalition by clarifying that we're talking about substantial control, which is, from our perspective, reasonable, but preserving the reference to terrorist group, not just listed entity. So with that sub-amendment, we would be supportive of the amendment.
Maybe as chair, I can ask if one of the officials can just speak on this or share some comments on what they think of this amendment? Not the sub-amendment, the amendment as it is.
Well, Mr. Chair, I may, if you would like, clarify that this A3031 is the power to issue an authorization. So the provision on obligations, potential criminal liability, remains for providing support to a terrorist group, whether listed or that meets the requirements. So this amendment would limit the ability to ask for an authorization to situations where there is substantial control. So in principle, at least, a terrorist group that has less than substantial control, to which an entity has to deal with without unavoidably, would not be able to apply for an authorization.
Ms. Demoff?
Obligation still remains. The ability to apply for an authorization would be limited.
So I need some clarity on what you just said. They would, by adding the word substantially controlled, they would not be able to apply, or they would be, like, what is changing for an aid organization?
So the obligations as in the existing law as reformulated in C41 are in 83031 and 83032 for knowingly supporting terrorist purposes and knowingly supporting terrorist organization. 83031 is the power given to the Minister of Public Safety to issue an authorization. This amendment limits the power to issue that authorization. So the existing law would remain a potential liability, but the ability to apply under a situation that does not meet the requirement of substantial control would be removed.
So you're saying that it would, if you're an aid organization working in a country that is, they would still be at risk of criminal liability, but the minister is unable to grant the authorization because of the wording of this? Is that what you're saying?
In principle, at least, yes. It's possible that factually, if there's no substantial control, there would be no liability. I can't speak to the application of the law to specific facts, but in principle, at least from a legal scope perspective, this would be reducing the scope of the minister to provide authorizations for those who wish to apply for them.
So it's not actually giving them more ability, it's giving, I'm looking at it from the aid organization's perspective, because my colleague is correct. This is something that was asked for by the coalition of aid agencies. From what you're saying, though, it would put them more at risk than less at risk.
I defer to them to assess their risk in light of particularly the new amendment that carves out humanitarian assistance. But yes, it does reduce the scope of the ability of the Minister of Public Safety to issue authorizations.
So they could be working in an area, and unable to get an because we're only talking about development assistance now, right? Because the humanitarian assistance has been carved out. So for development assistance, somebody is building a school somewhere. Is what you're saying is that this would mean that the organization would not be able to get an authorization where they would be currently?
Correct, for any of the purposes of B through G of that provision, including not just non-governmental organizations, but also, for example, the Canadian government, Canadian government officials.
Ms. McPherson?
But my understanding, and perhaps I'm incorrect on this, but my understanding is that that authorization would not be required because, frankly, if there is not a substantial if it is not substantially controlled by terrorism, it wouldn't necessarily, the organizations wouldn't be at risk of being charged with this. Because otherwise, what you're saying is that we would have a list, we won't have a list, we won't know anywhere, but if there is any terrorist activity at all in a country at all, then they have to apply for an exemption. But that's impossible because that's every country that international development works in. So really to say that you need, you couldn't go, I can't even think really of a country that people are doing development work in that doesn't have a terrorist bit to it, however small. So realistically, we wouldn't have to have the authorization because it is not substantially run by that. So of course it limits the minister, but the minister shouldn't have a role in this anyway. He should be limited.
I take your point, and I'm certain that there are some organizations and their legal advisors that take the view that this authorization would not be required, and if that's what Parliament chooses to pass the legislation, then that is its prerogative. My point would be that if you are an organization or a government entity that wishes to secure yourself protection from potential liability of existing provisions, so specifically 83031 or 83032, because you are concerned that you are giving indirectly or directly property to a person who is, let's say, a terrorist group. In other words, you know that the organization might use in whole or in part for the purpose of facilitating out any terrorist activity or for the purpose of benefiting any person who is facilitating or carrying out such activity. So in other words, you know the organization is doing terrorist events, and you're concerned that you're somehow giving funds to them that could violate the substantive provision, which is 83032, then the scope under which you could apply would be more limited. Perhaps you don't need to. Perhaps there's consensus amongst relevant organizations, including the Canadian government, that you're not required to do that, and you'll be safe from doing so, whether in Canada or abroad. But I am simply pointing out that that is the effect of the amendment.
Yeah, I appreciate your point, Mr. Brookfield, and I'm open to reconsidering what I said previously. And this is a challenge with, I think, all of these amendments. This is as I understand it. You can please jump in afterwards. But there's certain activity right now that is permitted, and there's certain activity that's prohibited. And this introduces a third category, which is activity which is permitted if authorized. Right? If we narrow that authorization regime, we're only helping these humanitarian organizations if in the process of narrowing that authorization regime, we clarify that activity that no longer requires authorization is permitted. But if we narrow it in a way that says that activity that no longer requires authorization is necessarily prohibited, then we're not making anybody better off. So I think if we're putting forward amendments that have the effect of narrowing the authorization regime, we also have to have language that clarifies what happens in cases where that authorization is no longer available. Is it necessarily permitted or necessarily prohibited? And I think we have to be very careful about that. Which is why, again, we've put forward language that says that the government has to provide guidance about areas where this applies, and that organizations who in good faith follow that guidance won't be prosecuted. I think without the clarity that people won't be prosecuted if they listen to the direction they're given, then may create more problems than we solve. I'd welcome your feedback on that.
I just say I agree with your point. I think from a legal perspective, it does narrow the ability to authorize. I think part of the argument, and I don't want to speak for others, may be that in highlighting the risk, the authorization regime might create greater concerns. And I think some organizations have said that. But from a purely legal perspective, I will say this does narrow the ability to issue exceptions to the existing law. It does not affect the existing obligations.
Right. It doesn't permit anything that's currently prohibited. It just narrows the ability of the minister to issue authorizations. Yeah. Yeah, so to the point, they shouldn't need authorizations, but if they, yeah, if something should be permitted, then we need. I mean, that's why we supported the humanitarian exemption, right? Because we want to say that certain activities shouldn't require authorization; they should just be permitted. But if the effect of an amendment is to leave open the question of whether something, if it's no longer authorized, if it will therefore potentially remain prohibited, then it doesn't help the problem. That's the dilemma.
Ms. Damoff?
Yeah, I apologize that I hadn't had this before to be able to go through it. So, but just based on what you're saying, and I'm not a lawyer, so, but the law, the terrorist financing law, does not change. This amendment, though, would limit the number of authorizations that theoretically limit the ability of the minister to issue authorizations. So the group would be in limbo, basically, of being outside of the law. That a group would be outside the existing terrorist financing law, while at the same time being unable to apply for the authorization for development assistance. Am I getting that correct?
Potentially, yes. So I believe my colleague has more to add from a practical perspective.
I guess I guess it depends on the delta between control and substantially control, and how that's interpreted in a case-by-case basis.
I just want to jump in and clarify one thing. Ms. McPherson is 100% correct. None of these activities are prohibited. Humanitarian assistance, development assistance, all of that can continue and should do. The law against terrorist financing remains in place, and channeling funds to a terrorist organization will always be illegal. What the intention of this amendment is to do is where an organization or a government actor finds themselves in a situation where a payment to a terrorist organization cannot be avoided, airport fees, taxation, other service fees, because an organization is substantially or in control. And I absolutely defer to my colleague from Justice on the use of the word substantially. But the purpose of it is to say you will not be held liable for payments you cannot avoid. It is not about saying what you can and cannot do in country. It simply says we will protect you. And for that reason, I would suggest that it's in everyone's interest to make this as broad and applicable as possible, so that cases can be assessed and there's enough scope to provide authorizations as broadly as we possibly can.
Ms. McPherson?
My big problem with this, and I think that we may have, we've actually gone down a road that I think is not correct. And I think that the reason of that is we are making providing international development a crime that we need an exemption from. We have chosen to make we are saying that international organizations or international development organizations require an exemption, where they shouldn't require an exemption to do their work. They should get to do their work, and in very, very strange circumstances, like the Taliban in Afghanistan, they should require an exemption. But in most cases, I would suggest almost all cases, organizations should not have to apply to do the work that they do. So what we're doing here is we're actually saying that this narrows the scope of when you need to apply. Absolutely, because I don't think any organization should have to apply. I think they should be exempt, because every one of these organizations is in fact trying to do life-saving work around the world. So from my perspective, we're thinking about this the wrong way. We're thinking about how to protect from funding terrorists, and we're not thinking about the fact that these organizations, not every organization has to prove that they are going into these communities for the right reasons, that they are doing the right thing. And in my, I mean, another example I will give for you, I was sort of thinking, and I literally can't think of a country where international development happens where there isn't some terrorist activity. So let's say Mozambique, one of the biggest recipients of Canadian aid, one of the biggest recipients of global affairs aid. There is terrorist activity happening right now in Mozambique. So that means any organization that wants to work in Mozambique now needs to apply for this. That was not what this bill was intended for. This bill was intended for situations like Afghanistan, where we have a terrorist organization running the country, substantially controlling the country. If we start applying this to every country where terrorism is happening, we can't have development work in Canada. Because we have Canadian organizations that are involved in terrorism in this country. Like, it's absurd. We're thinking about this just the wrong way, I think. We're weaponizing and making it a crime to provide international development. That's not what this bill was intended to do.
Mr. Genuis?
Yeah, I'm trying to work through this. I see things a little bit differently insofar as I think this legislation applies, as currently written, it applies to cases where areas are controlled by terrorist organizations such that international development organizations must inevitably deal with them in some way before delivering that aid. So it's not about is a terrorist organization operating in the country, but if in the example of Mozambique, if there's a particular locality where it is impossible to deliver development assistance without in some way interacting with, paying tolls to a terrorist organization, that would be the case where an authorization would be required, not just because they're present in the country. And I think the point from officials is, if we say that this legislation that the authorization regime is only available in cases where there's substantial control by terrorist organizations, that may mean that an organization that wants to deliver development assistance to that narrow locality in Mozambique can't even apply for authorization. It may mean that they just can't do the work, period, because they have to interact with terrorist organizations to do the work. They can't apply for authorization, so they can't do the work. So I think the argument in favor of like my argument would be, let's create an obligation for the government to provide information for organizations to use, but let's also create broad parameters in which the authorization regime can be used, while trying to provide as much clarity as possible to development organizations about when they do and don't need it. The point is just, like, you don't need authorization to work in a country where there's a terrorist organization, where there's terrorist activity. My sense is you need authorization if, outside of the humanitarian exemption, if you're going to a place. I think Nigeria is maybe a logical example, right? Nigeria has like certain spaces which are unfortunately not under the effective control of the central government, and but the country is substantially controlled by the central government. So if you're trying to deliver development assistance to areas that require some interaction with a terrorist organization, you would need the authorization regime in order to do that. And if the authorization regime is not available to you, then you just couldn't do it. Like our goal should be to offer more space for development organizations, not less. And I hear in Ms. McPherson's comments, I think a broader critique of the bill, which I'm sympathetic to. But I think we're in the spirit of trying to work with what we have. I don't think, upon reflection, that this amendment actually makes the existing bill better. I think it may narrow its usability by humanitarian organizations.
Mr. Jennings, are you withdrawing your sub-amendment then?
No, I can't withdraw it anyways, but I'm happy to leave my sub-amendment on the table. I think the sub-amendment improves the amendment, but I still don't think I'll support the amendment. So.
Shall we go for a vote?
Just very quickly, I'd just like to point out.
Person, sorry.
Thank you. I would just like to point out that this is something that the sector has asked for writ large. The Aid for Afghanistan has asked for this. They are the experts in this field. They are the experts in providing international development around the world. We are not the experts. And in fact, we are being given a public safety argument. And I would just suggest this is why we need to listen to experts. This is why this amendment is here.
Okay. We shall sub-amendment to 3 point,
Mr. Genesis amendment.
Mr. Jenis, sub-amendment to NDP 3.1, right? Carrie? On division recorded, sub-amendment. Get a recorded vote.
On division.
Just do it on division.
Okay.
Yes, no, nods.
Yes. On division.
Yes, 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 sub-amendment. Sorry? Adopted on division. Now, shall NDP 3.1 carry as amended?
No.
We'll do that recorded.
So on NDP 3.1 as amended, Madam McPherson,
Yes.
Mr. Genwis,
No.
Mr. Moore,
No.
Mr. Brock,
No.
Sir Van Popta,
No.
Madame Damoff, Madame Brière,
No.
Madame Diab,
No.
Monsieur Soubery,
No.
Madame Dillon, Monsieur Brunel Duceppe, pardon,
Oui.
it's 2-9.
2 to 9. The motion does not carry. The amendment does not carry. Mr. Jennings, do you want to move CPC 1?
I will move CPC 1. And unless there's a ruling from the chair, I will proceed with.
There is a ruling. Bill C-41 amends the criminal code to create a regime under which the Minister of Public Safety and Emergency Preparedness may authorize an eligible person to carry out in a geographic area that is controlled by a terrorist group and for certain purposes, certain activities that would otherwise be prohibited. The prohibited activities within the scope of the bill are set out in existing paragraph 83.03 sub B, which becomes new subsection 83.03 sub 2 of the code, and specifically concern the collection of provision of property or services for use by a terrorist group. The amendment proposes to allow the minister to authorize an eligible person to carry out activities that would otherwise be prohibited under the other provisions of Part 2.1 of the Criminal Code in geographic area that is controlled by a terrorist group. As House of Commons Procedure and Practice, third edition states on page 70, an amendment to bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, allowing exceptions to prohibited activities under the whole of Part 2.1 of the Criminal Code is beyond the scope of the bill. Therefore, I rule the amendment inadmissible.
All right, I'll challenge the chair then. CBC 1.
CBC 1.
Yeah. Everything's out of scope. Sorry.
He's challenging the, so
Do we want to recess?
Chair, could we suspend for just a minute?
sure, we can suspend. Suspended. Guys, if I can have some quiet. As the bells are ringing, and I think we were suspended, so there's still discussions going, I'm going to adjourn for the day, as I think the vote is at 5:35-ish, and bells are ringing, and I don't believe we have unanimous consent to sit longer, so we shall adjourn till Wednesday.